In today's episode of Legal Insights, we are going to show you how a 13 billion Kenya shillings landmark case involving Kenya Airports Authority and the firm of Otieno Ragot Co changed the game. Now, have you ever wondered how legal costs are determined? Or have you ever wondered how much one should pay the advocate? Answers to this matter of public interest were answered by Justices Martha Koome, Mohamed Ibrahim, Smoking Wanjala, Isaac Lenaola, and Joaquin Ndung'u. But how did this all start? In 2009, 54 individuals filed a lawsuit against Kenya Airports Authority, each seeking compensation of about 250 million, claiming that KAA had compulsorily acquired their land without adequate compensation. In total, they sought a staggering sum of 13,932 million Kenya shillings in damages. So, to defend itself against these claims, Kenya Airports Authority engaged the law firm of Otieno Ragot Co advocates who professionally had the suit preliminary staff out with cause for want of jurisdiction. Essentially, the claim should have been filed before the Land Acquisition Compensation Tribunal and should only have been brought to the High Court as an appeal from the tribunal's decision. As a result of the suit being struck out with costs, the value of the subject matter remained undetermined. KAA's advocates, having done their work, filed a party and party bill of costs, with the advocates seeking a sum of Kenya shillings 130,704,900 as instruction fees, which sum was pegged on the 13,932 million earlier sought by the plaintiffs. The bill was, however, taxed at the sum of Kenya shillings 151,650,000 and a certificate of costs issued. KAA contested this bill and filed an appeal challenging the taxing master's decision by way of a reference and sought stay of execution orders, which were granted by Justice Ali Rono. The reference presented several critical issues like: how should instruction fees of advocates be assessed? Does a certificate of party and party costs bind the taxing officer when assessing advocate-client costs? Should instruction fees be so high as to obstruct access to justice? And is the advocate-client bill of costs independent from the party and party bill of costs? Now, to answer these questions, Justice Ali Rono examined the Advocates' Remuneration Order, specifically Schedule 6, which governs how legal fees are taxed. The court also considered the provisions of access to justice under Article 48 of the Kenyan Constitution, as well as Rule 16 of the Advocates' Remuneration Order. So, in the reference, the taxing master held that she had the discretion to determine reasonable compensation for work done by the respondent, considering that the subject matter of the case had not been determined. Consequently, the taxing officer assessed the instruction fees at Kenya shillings 5 million and taxed the total advocate-client costs at the sum of Kenya shillings 8,759,022 shillings, all the way down from the sum of Kenya shillings 151,650,000 earlier taxed. So, the judge held in this case that party and party costs should not simply be taken globally and increased by 1/2. Rather, a taxing officer must consider each item separately, bearing in mind the principles of taxation. So, aggrieved by decision, the law firm of Ragot, with leave of the High Court, appealed to the Court of Appeal, challenging the taxing master's decision by way of a reference as provided under Rule 11 of the Advocates' Remuneration Order. So, more questions were raised, including whether the instruction fees determining the taxed party and party cost ought to have been applied to the advocate's bill of costs. 2. Whether the taxing officer was entitled to exercise her discretion to determine the instruction fees afresh in a matter that concerned the same case. And lastly, whether the advocate-client bill of costs is independent from the party and party bill of costs. These questions, although raised in the Court of Appeal before the former Chief Justice Maraga, Justice Gatembu, and Mudgo, were answered in another appeal in the Supreme Court, where the court attempted to answer the following questions after KAA had argued that the matter at hand was one of public importance. More questions were raised in the Supreme Court, including what is the proper interpretation of the provisions of Schedule 6 Part A and Part B of the Advocates' Remuneration Order, in particular, whether the phrase fees prescribed in A above increased by 1/2 effectively takes away the taxing officer's judicial discretion in taxation of the advocate-client bill of costs. The second question was, what is the proper interpretation of the term subject value in instances where the subject matter of a dispute, although pleaded, is fictitious and unsubstantiated, and hence unascertainable from the pleading? The third issue raised was whether a certificate of taxation arising from an uncontested party and party bill of costs is in itself binding on the taxing officer in the taxation of the advocate-client bill of costs, and whether such certificate completely affects the discretion of a taxing master in assessing instruction fees of advocate-clients costs. And lastly, the fourth question which needed answering was whether costs awarded to an advocate should be allowed to be so punitive with the effect of obstructing access to justice as guaranteed under Article 48 of the Constitution. So, in a bid to settle the above issues, the Supreme Court scrutinized whether the party and party costs, which were uncontested, should dictate the advocate-client costs. In answering the first question, the court held that while a certificate of taxed party and party costs is final on the costs ascertained in the party and party costs, instruction fees are sustained thereunder are not in itself binding when it comes to assessment of advocate-client costs. Court further held that taxing officer may exercise her discretion and depart from the ascertained instruction fees and give reasons for such a departure. So, in answering the second question, court held that with the suit having been struck out preliminary and not heard to finality, the subject matter could not be ascertained. Hence, the initial assessment of 196,044,750 as instruction fees was exorbitant and an impediment to justice. Court held that as the suit was not determined to completion, an unsubstantiated and an indeterminate figure could not be used to emphasize on the need of calculation of the legal fees. In this matter, court looked at the reasonableness in legal fees while aligning the economic realities so as to avoid unjust enrichment. In answering the third question, the Supreme Court noted that while a certificate of costs is final, it does not automatically bind the taxing officer. A taxing officer must still exercise discretion based on the specifics of the advocate-client relationship and the nature of the work performed. This means that in assessing instruction fees, the subject matter should be identified before value of the subject matter. So, in a nutshell, an advocate should only be entitled to payment of a reasonable fee, which is commensurate with the work done. In answering the fourth question, the court were relying on the guiding principles aptly pronounced in the Premchand case, held that courts owe a duty to the general public to see that costs are not allowed to arise to levels as to deprive parties access to court and justice. Courts further held that the general level of the remuneration must be reasonable enough to attract parties to court and termed a reasonable fee as one where the taxing master, after application of their discretion, established a true representation of work done by an advocate. So, in finality, court held that instruction fees ought to take into account the amount of work done by an advocate, the prevailing economic times, and should be reasonable to a level where charges should not impair the access to justice. So, in the end, the Supreme Court set aside the majority judgment of the Court of Appeal and reinstated the High Court's ruling, emphasizing on fair compensation without exorbitant fees. On lessons and importance, 3 lessons were learned here. The importance of fair legal practices, the duty of the court to ensure that justice remains accessible to all, regardless of financial status, the role of the judiciary in balancing legal costs and maintaining the integrity of the legal profession. Thank you for joining us on this legal journey. Make sure to subscribe and hit the bell icon for more insightful analysis of pivotal legal cases. Next time, we'll discuss more cases that have shaped up our society and the legal landscape. Stay informed, stay empowered, and don't forget to subscribe. See you on the next case.